Good afternoon, everyone. Thank you for joining me for another installment of Miller Johnson's monthly employee benefits webinar series. I'm Jeff Gray. I'm a member in Miller Johnson's employee benefits practice group. Before I get to our title for today, though, or before I get to our presentation, I just have a couple housekeeping slides. As you probably know, we do this webinar series on a monthly basis. This slide shows our upcoming webinars, so keep those in mind. And if you'd like to register, there's a link below to register for a future webinar. Keep in mind too that we always appreciate getting upcoming topic ideas. So you can email those to us. You can include those in the link when you register. So we'd like to hear from you either in the Q&A feature today or actually in the post-webinar survey afterwards. If you have any great ideas, let us know. We're always looking for good topics. So on to the topic today. If you weren't tired of it already, we have another presentation on Secure 2.0. I titled this Secure 2.0 Update Correcting Errors. It's kind of a goofy title, correcting errors to what? Well, today we'll talk about correcting retirement plan administration errors under Secure 2.0 and the changes that were made there, including some very recent guidance that came out just since our last webinar. And then also corrections to Secure 2.0 itself. The legislation itself has a number of errors in it, or at least lacks clarity in several different ways. So we'll talk a little bit about where that's at as well towards the end. So in terms of an overview of our short webinar today, we'll talk about the current process for correcting retirement administration errors under the Employee Plans Compliance Resolution System, which is that EPCRS referred to in the top bullet, and then the changes to that process that were made under Secure 2.0, which, as you might know, was the kind of major retirement plan legislation that was passed at the very end of 2022 last year. Just within the last couple of months, or the last month really, we've also had guidance from the IRS regarding those provisions of Secure 2.0, and that's IRS Notice 2023-43. So if you Google that, you can find the actual notice if you're interested in reading it. We'll talk a little bit about that. Then we'll talk about the kind of errors I was referring to before under Secure 2.0 and a House and Senate committee letter that addresses some but not all of those errors that was recently issued in May. So let's start with the background. The EPCRS is really described in a revenue procedure that the IRS issues. The current version of it is 2021-30. There was a prior version from 2019. The IRS kind of tweaks this whole program every few years, it seems like. So you can find versions of this going back to 2008 and maybe earlier. But this generally describes the process for correcting errors in retirement plans in order to maintain the tax qualified status of that retirement plan. Because if you've had an operational error or another type of error, it can affect the tax qualification of your retirement plan. So the idea is to make corrections whenever we can, really to preserve that qualified status and avoid potential penalties, and keep your financial auditor of the plan happy if your plan's large enough to be audited every year. This program really it kind of creates a distinction between plan document failures. That might be the failure to even have a plan document or the failure to timely amend a plan document, and operational failures. So those are really more that we see those more often. Those are just the typical kind of operational failures that you may have experience with, where you've been administering your plan in a way that doesn't necessarily comply with the specific terms of your plan document. It is not uncommon at all for a plan document to say one thing and then to have the payroll department or the record keeper handle something completely differently. And whenever you have that mismatch, you have a potential operational failure. And so there are really three general approaches for correcting failures to a retirement plan. The first is the easiest and the quickest and the least expensive. And that's what we refer to as self-correction. That's where the employer identifies the mistake, corrects it on its own based on guidance under EPCRS, keeps a record of the correction, and then establishes new processes to avoid the error in the future. Not all errors can be self-corrected, which we'll talk about today. The other more expensive and more time-consuming is what we call voluntary correction, and that's really where you file an application with the IRS. So you pay a filing fee. You describe in that filing the error, who discovered it, what the processes were at the time, and then how you propose to correct it. That process right now is taking quite a long time. It's taking usually at least a year for the IRS to make a decision on those cases. And typically, voluntary correction applies where you've got some sort of issue that's either very significant, so you want to have the IRS's stamp of approval on it, or it's something that just can't be self-corrected under the current approach. So it's not uncommon to file what we call a VCP, voluntary correction program filing with the IRS. The last option here is really more what happens if you get audited and the IRS finds a problem. There's a process in EPCRS for closing the audit where you pay a negotiated kind of penalty. So you work with the IRS to fix the issue, pay a penalty, and then move on. As I mentioned, only certain failures are eligible for self-correction under EPCRS, and there's also a kind of outer limit on the time that you have to correct something. So under EPCRS, an important distinction is between insignificant failures. The IRS refers to retirement plan errors as failures, and you have to describe them as failures to the IRS. It's kind of an odd nomenclature, but it follows through all of the correction program documents. And so if you have an insignificant failure right now, you can basically correct it indefinitely. You can correct it whenever you find it, even if it happened many years ago. If you have what the IRS refers to as a significant failure, that currently, or at least prior to Secure 2.0, was subject to a limit. You had to self-correct that no later than the end of the third plan year after the year in which the failure occurred. And EPCRS provides a kind of facts and circumstances test to determine whether something is significant or insignificant. And that distinction actually continues to be important after Secure 2.0, which I'll describe a little bit further. But basically, it's a facts and circumstances test. It takes into account how many employees were affected, for example, how long ago it happened, and the plan assets that are involved in the failure. So if it's big enough, affects enough people, and went on for long enough time, it's going to be considered significant. So that's the kind of where we were before the end of 2022 when Secure 2.0 was passed. What Secure 2.0 does under Section 305 is it says that really any quote unquote eligible inadvertent failure can now be self-corrected basically at any time, but there are limits to this. First, though, what is an eligible inadvertent failure? It's really any sort of failure in a retirement plan that is not egregious, doesn't involve misuse or diversion of plan assets, and is not an abusive tax avoidance transaction. And the thing to keep in mind with those 3 points is really just that the ability to self-correct things is limited to, inadvertent errors that we were trying our best and just goofed up. They're not intended, though, to fix something that the employer may have done to intentionally skirt some tax rules, for example. But 99% of the errors that we deal with are eligible inadvertent failures. They're just kind of understandable errors in the administration of the plan. But this new rule is subject to some limitations. you have to have established practices and procedures to prevent the errors. Now, this means something more than just having a plan document. It means you have a plan document and you have some practices and some procedures that were designed to follow that plan document and to administer the plan appropriately. I think, most employers have this. This is not a huge hurdle, and it's the same hurdle that has always existed in order to self-correct an error. The employer also has to have a specific commitment to correct the error before receiving notice of an IRS audit. So you can't generally self-correct a significant failure after you get notice of an IRS audit. In the past, you would have had to have the correction basically done, substantially completed, basically, before you get an IRS audit. Once you get notice of the audit, in the past, you couldn't self-correct anything. It was too late at that point. Now you just have to have this specific commitment. I'll talk a little bit more in a future slide here about what that really means. But the other important part is that the failure has to be corrected within a reasonable time after discovery. So that's a new component. And that's important to keep in mind, because really what you're doing is you are swapping this third plan year following the year in which the error occurs, this outer limit, for a new rule that kind of ignores that outer limit, but says you've got to correct within a reasonable time. And again, we're talking about significant corrections here, significant errors, because if it's insignificant, you can continue to correct that during an IRS audit, for example. So again, there's no longer any last day requirement for significant failures. That's a key component of Secure 2.0. The other issue is that in the past, you could correct certain loan failures under EPCRS, and you can still do that, but it was always unclear whether you would still have a problem with the Department of Labor, because most loan failures violate ERISA as well as the tax code. And what Secure 2.0 says is that, well, if you correct the loan failure under EPCRS, once the IRS updates it for Secure 2.0, then the Department of Labor also needs to accept that correction. And there's a kind of proposed rule on the DOL side of things to recognize that. Another change is that the IRS is directed to expand EPCRS to cover the correction of IRA failures, which it doesn't currently cover. The guidance that just came out recently does not cover that item. That's still kind of on hold, but that's part of Secure 2.0, though, was to allow IRA corrections under EPCRS. Another, just in terms of background, now this is not covered in the most recent guidance, but this is just kind of a repeat of another item that we've talked about under Secure 2.0, is that it expands the ability to correct overpayments. We have more options for handling inadvertent benefit overpayments. So that's an example where a participant has taken a distribution and may have been overpaid. And oftentimes we find that the employer just doesn't want to go chase that participant for the overpayment, either because it's not worth chasing the person down, or they just feel like the person probably relied on the amount that they were getting. So generally speaking, a good change under Secure 2.0 is that employers don't have to recover those overpayments, except in a couple of limited circumstances. If there was an overpayment that somehow resulted in a loss to a different participant, you'd have to recover the overpayment. And if your defined benefit plan is underfunded, then you also need to seek that overpayment. Another good change is that this new rule doesn't affect any kind of overpayment recovery arrangements that you would have already had in place. Well, there's some new rules. If you decide to go after the overpayment, there are some new rules and some new restrictions that apply. But thankfully, those don't apply to any recovery arrangements that would have existed as of the end of 2022. So in terms of those limitations, if the employer decided to recover those overpayments, you can't recover overpayments that have been made more than 3 years ago, or that began over 3 years ago. You can't charge interest or fees on the overpayment that you're trying to recover. If the participant's receiving payments, which would happen like in an annuity payment, this would affect defined benefit plans primarily. The recovery has to be spread over at least 10 years and can't reduce the annual benefit by more than 10%. So that's a pretty big restriction. You can't use a third-party collection agency or threaten litigation. And there's a general rule that you can't collect from the spouse or beneficiary. All of these limitations don't apply if the participant is culpable. So if the participant or beneficiary kind of knew that they were overpaid and is culpable in some way, then you're not subject to these restrictions that I just described. And I think that we still need some more guidance about what this even means, because it's not uncommon to, it's thankfully not that common, but it's been known to happen where the employers just paid the wrong beneficiary. And if that beneficiary maybe knew that he or she was not the beneficiary, that person's certainly culpable and these rules wouldn't apply. But sometimes the beneficiary just has no idea. They assume that they were named as the beneficiary. So that's one of those kind of open items that's a little unclear. That really has not been addressed in this new IRS notice that came out very recently. This new IRS guidance from earlier this year is interim guidance regarding Secure 2.0 that we just talked about. And it's intended to kind of hold us over until the IRS more formally updates EPCRS. So the IRS has a direction to update that program based on Secure 2.0. It was unclear really how the IRS would interpret those Secure 2.0 provisions before it formally updated the program. So this interim guidance is helpful just to kind of cover us between now and whenever that happens. I think it's got to happen by the end of next year, but agencies have also been known to blow their deadlines on that sort of thing. This guidance is important because it confirms that you can self-correct any eligible inadvertent failure before the program's formally updated, which is helpful. Also, importantly, it confirms that employers are able to self-correct those eligible inadvertent failures, even if they arose before Secure 2.0 passed at the end of 2022. So that was also one of the unknown questions. Do we have this greater flexibility really only for errors that happen in 2023 and beyond, or can we use this new standard for errors that we find out about that may have occurred in years prior to the passage of Secure 2.0? And this guidance from the IRS confirms that we can, in fact, use that this expanded correction for errors that arose before Secure 2.0 was passed. So that's a good thing. Also confirms that, as I mentioned, the time period for correcting these inadvertent failures is indefinite. That limitation of the third plan year following the year in which the error occurred for significant failures no longer applies, which is a good thing. That also it confirms some of the things that you might read into Secure 2.0 based on the language there. So there are certain limits in EPCRS in the current program about errors that can be self-corrected. For example, to self-correct a significant error, you had to have a determination letter for your plan. That seems like a requirement that was wiped out under Secure 2.0, and this guidance confirms that. So that's not required, even though most plans have those determination letters. It removes, so there are a couple categories in EPCRS that just almost flatly are called out as something you can't fix, something you can't self-correct anyway. You can file a VCP and ask for correction, but you can't self-correct it. Those would be demographic failures and employee eligibility failures. Demographic failures are really where you haven't covered enough people with your plan. So maybe you would fail if you might have failed the minimum coverage test under 410B. That would be a demographic failure. That's something that's just called out under the program as something that can't be fixed. This notice confirms that those broad exclusions no longer apply. But as I put in parentheses there's some limitations to this that I'll cover. It confirms that you can self-correct insignificant errors at any time, including during or after an IRS audit. That's not a new thing. That's just carrying over the past, but I think confirming it, which is good. And you can correct, as I was kind of describing before, you can correct significant errors, even if you've got an IRS audit, as long as you've made a specific commitment to correct it before you get that notice. Specific commitment really means that you're actively working towards correcting it. It's not that you've learned about it and you've mentally thought to yourself, gee, we should correct this. It's that yes, you've found out about it and you have steps in place and you've started working towards correcting. As long as you've done that, then you're in a good place. But this also highlights the reason, just like it's always made sense to correct these as soon as you can, to make sure that they're at least in process before you get notice of an IRS audit. There's a few items that still cannot be self-corrected under this notice. Most, like I said before, well, let me back up a little bit. There are only certain plan document failures under the current EPCRS that you can correct within a certain window of time. That limitation was removed, but the IRS is saying that if you fail to adopt a plan document altogether, that's something you can't self-correct. You've got to come to the IRS to fix that. If you have an orphan plan, which is really a plan that was abandoned, you can't self-correct plans, those types of plans. And those do sometimes happen kind of unintentionally. Usually in the example of a seller in an asset sale, the seller usually holds onto the plan and is responsible for winding it down. And it happens sometimes that the seller, probably excited to have just sold the business, fails to do that, and the plan just kind of hangs out there. Also, significant failures in a terminated plan. So we terminate retirement plans, again, oftentimes following some sort of corporate transaction. You could theoretically, after you terminate it, have a failure of some sort in distributing assets, for example. Any kind of significant failure in a terminated plan cannot be self-corrected. It still needs to go to the IRS for approval. I mentioned earlier that demographic failures are just generally called out as something that can't be corrected, self-corrected under EPCRS. The guidance kind of maintains that for all practical purposes for now. It says that, and again, just to back up, all of the comments, all of the information in this notice, it's intended to apply only until the IRS formally updates EPCRS. Once it does, I think this notice goes away. But the IRS is basically saying if you have demographic failures, you can't fix those unless you follow a kind of separate step in the Treasury regulations, where within 9.5 months of the end of the plan year, you sign a plan amendment that basically allows the previously ineligible participants to participate in the plan, thereby kind of fixing the demographic failure that you might have had. So outside, you can still do that. That's still in the regulations, but outside of that, you really can't fix that under this notice. Retroactive plan amendments that reduce benefits still are not permitted. This went through a few different iterations under the EPCRS. Most recently, the IRS confirmed that you could correct an operational error through a retroactive plan amendment, so long as the retroactive amendment basically increased benefits to participants. So you couldn't, and the way this comes up usually is like a bonus error. You may have coded bonus payments as includable in compensation, but you didn't count them in calculating deferrals and employer contributions. You've not been able to go back through a retroactive amendment, to make the plan document align with your operations, because in that case, doing that would be less favorable to participants, because you're retroactively amending the plan basically to take away that benefit of counting that compensation. That still holds true, and that still holds true under Notice 2023-43. You can, what it basically says is you cannot self-correct through retroactive plan amendment anything that is less favorable to participants. But if it's even if it's kind of neutral, I think you probably could do it under this new guidance, even if it doesn't necessarily increase anything. But what the IRS is just confirming here is that you still can't do retroactive amendments that take anything away or make it less favorable. There's some other failures that you cannot correct under simple plans, simple IRAs. They can't self-correct, excuse me. And ESOPs. The ESOPs have an anti-abuse provision under Section 409 P of the code that is really just a horrendous penalty if you violate it, and it's easy to violate it through deferred compensation programs that apply to owners. Just horrible things happen to your company. There's terrible tax consequences. It would have been great to be able to self-correct that as an eligible inadvertent failure, but at least at this point, this notice specifically calls out that there's no relief for ESOPs under 409P at this point anyway. Maybe we'll see that change. As I mentioned earlier, there is now, instead of an outer time limit in total, that 3-year limit for significant failures, now under Secure 2.0, any eligible inadvertent failure has to be corrected within a reasonable time after it's discovered. And the general rule is 18 months. So you've got 18 months after you find out about it in order to correct it. Seems like a lot of time, but that 18 months goes by pretty fast. There's also a little bit of a shorter rule, well, quite a bit of a shorter rule if you're trying to correct a employer eligibility failure. An employer eligibility failure is really where the employer is not eligible to have the type of plan that it's sponsoring. So maybe it's a employer with more than 100 employees and is trying to sponsor a simple 401k or simple IRA, or it is not a tax exempt or governmental employer and it's trying to sponsor a 403B plan. You can self-correct that issue, but you have to act pretty quickly, which means you have to stop contributions to that plan within 6 months after you've realized the error and correct the documentation. So there's a little bit of a shorter window there. And it's really these limits, there's some flexibility in these limits. The 18-month window, if you correct it within 18 months, it's deemed to be reasonable. But really it's facts and circumstances. So you could potentially go beyond the 18 months depending on the facts. So there may be some reason why we couldn't get it done within 18 months, and that may be okay. The correction program, the Notice 2023-43 also emphasizes something that's important to keep in mind. It's at the very end of the notice. This is not new, but it's just an important reminder that when you do self-correct something, you've got to keep some documentation. You've got to identify the failure, the plan years involved, the number of employees affected, the date when the failure was discovered, basically all the items on this list. The idea is if the IRS comes in to audit the plan, the IRS doesn't want to have to hunt around for this stuff to figure out that there was an error and that you fixed it. You need to have documentation that shows how you fixed it, when you fixed it, and what you've changed and put in place to prevent those errors in the future. So that's a quick kind of run through on correcting retirement plan errors under Secure 2.0. But then I've got a couple slides here just on corrections to Secure 2.0 itself. And, this might not be super important for your day-to-day plan administration, but I think it's important to just know that if you do have an error in your plan and you need to go explain to the boss that there was an error, you might feel bad about that, but I don't think you should feel bad about it. This is complicated stuff. These errors happen quite a bit because the entire retirement plan space has gotten more and more complicated every year. And you can explain to the boss that, hey, even Congress, when it's writing these laws, it can't keep this stuff straight. So there's several provisions in Secure 2.0 that are just unclear or are wrong. One of them is that there's this concept of a starter 401k plan that's really employee deferral only, and it's supposed to be very simple to set up. And the idea was to make it more attractive than what we call payroll reduction IRAs. Because right now you can have kind of a hands-off employer plan where you're just taking deferrals, allowing deferrals out of an employee's paycheck directly to an IRA. But the way they wrote the law, the limit for the starter 401k is less than the limit for the payroll or deduction IRAs when it all goes into effect, which makes no sense. There's also confusion about the $5,000 small employer startup credit and whether the other credit that applies to employer contributions is included within that $5,000 or separate. There's a provision regarding, this one's getting a lot of attention, right? The provision regarding the ability to elect to have your employer contributions treated as Roth contributions. Those have to be fully vested when made, which makes sense if you're going to tax somebody on a contribution, that it would have to be fully vested. But it kind of arguably suggests that you somehow get to avoid the vesting schedule in the plan or something. It's just unclear exactly what that vesting rule means. And there's also just plain old missing paragraph in the legislation. Somebody missed it or fell out along the way, or because when you read it, literally seems to prohibit catch-up contributions in 2024 and beyond, just because of the way the legislation came together. And clearly that's not intended. There's also some confusion about whether starter 401k plans can replace a simple IRA plan mid-year. There's new relief for somebody who has a terminal illness. If you qualify as having a terminal illness, you're not subject to the 10% excise tax for early distribution. So if you're taking your deferrals out before age 59 and a half, you're not subject to that excise tax. But it's unclear whether the terminal illness itself is an independent distributable event, like separation from service. So it's not clear whether I can even get access to that money. Clearly, I could get, if I have a separation from service and I have a terminal illness, then I can. But that's one of the things that's unclear. There's also one of the things that Congress tried to clarify in Secure 2.0 is the vesting rule for long-term part-time employees and how you credit them with years of vesting service when you're using this new 500 hours over 3 consecutive years rule. And there's just an incorrect cross-reference that seems to conflate eligibility service and vesting service. There's a higher catch-up limit for ages 60 to 63, but it refers to the wrong year. It's sort of like the limit that the legislation refers to doesn't align with when the actual increase in the catch-up limit goes into effect. And finally, there's the required minimum distribution provision. As you know, the minimum age at which, the age at which you have to start taking required minimum distributions increased as part of this legislation from 72 to 73. There's also an increase at the end of 2032, I think, that increases that from 73 to 75. But the way they wrote the legislation, it makes no sense for people born in 1958. If you're born in 58, you have both an age 73 and an age 75 beginning age, which again doesn't make any sense. So I think anticipating some of these errors in May, remember a few short months now after the legislation passed, the Senate Finance and the House Ways and Means Committees sent a letter to the IRS basically saying, hey, we know that there's problems here, but we want to make sure that you, IRS, understand what we meant. First, this letter confirms that Congress didn't intend to eliminate the catch-up contribution, so that's good. Not a huge surprise there. They're just basically saying, yes, that was a goof up. So we didn't intend to eliminate catch-up contributions. Confirms that small employer startup credit of up to $5,000 applies to the other credit that's available as part of that program for employer contributions. Also confirms that the increase in the required beginning age to age 75 applies to anyone who turns age 73 after December 31 of 2032. So that just sort of clarifies how that works, which is good because that some of our plan sponsors are wanting to amend their plans to address these required minimum distribution rules. And now we can at least feel a little bit more comfortable about how to draft those provisions, even though the amendment deadline is not for quite some time yet. Also clarifies that so part of Secure 2.0 allows plan sponsors to include a Roth IRA component within a simple IRA plan. And there was some confusion about whether the contributions to that simple IRA would count against someone's Roth IRA contribution limit. And this letter says, no, it does not. So you're not penalized your participation in a simple IRA is not going to affect your participation in your own Roth separate individual Roth IRA contribution. Now, this only covers, like I said, a handful of the 8 or 9 items I called out that are still unclear. And so the committee letter kind of concludes that they intend to introduce technical corrections to some of those, what they kind of admit as erroneous statutory language. So there's going to be more to come on this, but I just thought this was interesting because if you're, the takeaway from this all is you have more flexibility to self-correct errors in retirement administration, and don't feel bad when you have to do so because even Congress really can't keep it all straight. So anyway, that was a quick summary of a lot of information. So that's the end of my presentation. I don't know if anyone has any questions. I'm happy to answer them. I don't see any open at the moment, but I'll give maybe a few seconds here if someone's furiously typing, because it's kind of a convoluted area. Yeah, I mean, the EPCRS program is 140 pages, and the way to kind of formally correct things under that program is itself complicated. So the rules are complicated, and how to correct it's complicated. If somebody comes to us and says, "Hey, I did not administer this person's pay deferral election correctly," you just have to ask a series of questions. What type of plan do you have? Is it a safe harbor plan? Is it not? How did you mishandle the deferral election? Does your plan have automatic enrollment or not? When did it happen? And you ask this whole litany of questions to decide how much you have to put into that person's account to correct it. I mean, that's just one example of how complicated that EPCRS program is and continues to be. But maybe with this new revision under Secure 2.0, maybe it'll be a little bit more user friendly. I'm not seeing any questions. So with that, I think I'll sign off and thank you all for joining.